How long does a deposition take?
A deposition usually, it can take no more than a half of an hour. Sometimes, and if there's an interpreter present, for example, it may take longer just because of the need for translation. But normally a deposition wouldn't take more than an hour, 90 minutes tops.
So if I was involved in a car accident, what type of questions would the opposing attorney be asking me?
So the sort of questions you could expect from the attorney would obviously have to do with the facts of the case, the accident itself. The attorney would ask a series of questions regarding what you recall from that date. The attorney is looking to get from your perspective who's liable for the accident, at what point, if any, following the accident, did you start to experience pain? So there'd be a lot of questions focused on the accident itself, especially if it's a case where liability it seems to be at issue. The attorney would also likely spend a lot of time asking questions about the actual injuries or pain that you did suffer. They would, in all likelihood, be aware of the medical records and the treatment that you had received, so they would be in a position to ask you about that. How long did you treat? If there were some gaps in treatment, they would undoubtedly ask about that. And then finally, the attorney would also certainly be asking questions about how you believe that the accident affected you. They're trying to get a sense of what sort of damages your attorney would be seeking at some point. And what they're trying to do, I think, is both get a sense of what sort of a witness you're going to be, and also to frankly, to commit you to the testimony that you would give at the deposition, which again is under oath, and there's a court reporter there.
Can they ask me questions that are not relevant to my case?
They can, because even if a question isn't directly relevant to the case, it may be a question geared towards possibly discovering other information that might be relevant. What I always advise a client before a deposition, and I always take the time to prepare a client for what to expect, is for the most part, the other attorney has free rein and can pretty much ask anything that they want. Now, there are obviously some guidelines, I would say, of just decency and professionalism, and there could potentially be a question that not only would I state an objection to, but that I would go so far and tell my client, you don't have to answer that. But that's pretty rare. And the thing to keep in mind is that what might be relevant or admissible, or a question that could be asked during a deposition, is not necessarily a question that would ever see the light of day at a trial or even at an arbitration. So what I encourage my clients to do is just be as open and candid as you can be. Don't worry about whether or not the attorney has the right to ask you that question. Let me guide you on that, and then I would usually follow up after that and let them know what they can expect in the future.
What's the most important thing to remember during a deposition?
I think the most important thing to remember is that, number one, tell the truth. Number two, you're not expected to be anybody other than who you are. So, for instance, if you can't remember the detail of a particular question, if that's your honest answer, then that's the answer you should give. You shouldn't worry about the fact that you can't remember it. Even if it's something where you're thinking, I know I can remember the answer to that, it's escaping me now, just answer honestly. That's an honest answer. The other thing to keep in mind is don't offer any more information than what is being asked of you. A lot of times, and this is very understandable, a client will feel the need to not only answer the direct question, but to then provide a lot of commentary that they think will help explain that answer. I always advise my clients, don't worry about that. Make them do their job, which is their job is to ask the questions that will reveal for them the information that they're seeking. You don't have to do their job for them. I always encourage my clients to be cooperative and to be open. And although normally I think opposing counsel, they're asking the questions, they usually handle the deposition in a professional manner. There are times where I've experienced that attorney tries to use that as an opportunity to see if they can rattle my client or to try to come off as intimidating. Even in a situation like that, I always encourage my client, don't let that rattle you. Understand that I'm there for support. Again, what's going on in a deposition is not necessarily what will happen at a later proceeding, and don't let them get the best of you in that way.
What should I expect after the deposition?
After the deposition, once the transcription is complete, we will be notified that the deposition is ready for review. If you would like to review that, you have an opportunity to do so, and sometimes we do advise our clients to come in and review that. The purpose of that is to make sure that there weren't any errors in transcription from your recollection, and I often take an opportunity to do that myself since I was at the deposition. And I'm taking notes as well as paying close attention to the questions and answers that are being given.
My attorney told me that after the deposition, sometimes my case settles, and in my particular instance, they said I was going to arbitration. When does arbitration happen after the deposition? How soon can I expect to go into arbitration?
That can depend, but normally it seems as though arbitration usually follows a deposition by 1 to 2 months. Sometimes it could be a little bit longer. I don't think it is usually ever any sooner. The reason why a case may settle right after the deposition without any further proceedings, quite frankly, is that attorney, the other attorney who handled the deposition, realizes what a strong witness my client is, and realizes that the evidence creates a situation where more likely than not they stand to lose much more if we go to arbitration or even beyond that to jury trial than if we can resolve the case even at that point.